Hello, I'm Stuart Price and I'm a partner here in the corporate and commercial team at Lodders, and I specialise in commercial contracts and intellectual property. Terms and conditions form the cornerstone of the relationship that you have with your clients. They'll deal with such matters as when you're going to get paid, what happens to the goods when they've been delivered, what happens if there's a problem, things like that. The sort of basic arrangements that you would have with your clients to make sure that you can get paid for the goods and services you provided. Well, if you don't have terms and conditions, you don't really have any say in how your business is run. What do I mean by that? Well, what I mean by that is the fact that the law will imply certain situations. So say, for example, you say, well, we'd like to get paid, obviously, for the goods or services provided. You might think, well, we'd like to get paid within 10 days or 20 days or 30 days. But what the law actually says is that a customer only has to pay you within a reasonable period of time. And what you might think is reasonable is not necessarily what they might think is reasonable. Another example of where the law implies things is when it comes to when ownership of goods will pass. So, for example, you may think that the ownership of the goods will only pass to somebody when they paid for them. But actually the basic position or the implied position of the law is that they will pass as soon as they've been delivered. So you might find yourself in a situation whereby you've delivered the goods, the company you delivered the goods has gone into suffered some insolvency event. You haven't been paid for them and you can't get the goods back, so it's the worst of all worlds. So to try and redress that balance, you have terms and conditions in place that will set out the terms of the contract between you and your customer. So to use that example I just made there, you'd have a clause in the terms that said that the ownership of the goods will only pass when they've been paid for. So that there being, if they suffer an insolvency event, you would actually be entitled to go back into the customer's premises and recover those goods because they're still your goods at that point. Well, first of all, the most important thing is making sure you know when you're going to get paid. So, as I said earlier, you need to make sure that your payment terms are clearly set out. So if you say, look, I need to be paid within 30 days of either the date of the order or the date of delivery of the goods, then you would need to put that in your terms. You will also need to put in your terms if there's any implication if payment is not made on that day. Two things might arise from that. First of all, you might want to charge the client interest, or you might want to say, well, actually, we're entitled to suspend either performance of the services if they're ongoing, or suspend delivering any future goods until such time as you pay us up to date. So those are things that you've got to put in your terms. If you don't do that, then you could be in trouble yourself, you could be in breach of the law yourself. So, but if you make that a contractual obligation, then in your terms and conditions, then that's something you then can rely upon. Well, there's a couple of reasons why that's not a great idea. First of all, the terms and conditions have been written for somebody else. They may have taken their own independent advice, they've spoken to a lawyer, they've said what it is that they want, how they want to run their company, and the document has been drawn to reflect that. That's not necessarily how you want to be running your business. So you should actually think about how you run your business, how it operates on a day-to-day basis, and your terms should reflect that. So in order to do that, those terms should be written specifically for you. Secondly, the person that wrote those terms and conditions will own the copyright in those terms and conditions, and that means that no one else can use their terms and conditions without the permission of the person that wrote them. So I write sets of terms and conditions almost every day of the week, and that means either I or my employer will own the copyright in those documents that I write. That means, of course, that my clients who pay me for my services are allowed to use their terms in their business because that's the basis of our relationship. However, it doesn't mean to say that those terms can then be used by somebody else who hasn't engaged me to write those terms. And that's no different if you think about going on the internet, downloading somebody else's terms, using them in your business, because their lawyer or the lawyer or someone else has written those terms for them, and somebody else owns that copyright, if it's not even necessarily the person whose website you've used. So the risk there is that you're going to find yourself on the receiving end of a copyright infringement action by somebody for use of those terms. I suppose secondly as well, the danger with using somebody else's terms is that their terms themselves could contain mistakes, and all you would be doing is carrying those mistakes through. So there's a very famous example from a few years ago where there was a company called Seaborne Freight, and Seaborne Freight had won a government tender to provide freight services in the event that there was a no-deal Brexit. But famously, their terms and conditions warned people, or their terms and conditions said that you must check your meal before paying for the goods received. So clearly they'd had those terms and conditions from a local takeaway or some other fast food place, which clearly were not fit for purpose, and they then found themselves on the front of all the national newspapers as a result. I suppose the other issue that crops up from time to time, and it's usually obvious to me that they've taken their terms and conditions and they've copied them from somebody else, is when I see the jurisdiction clause. So at the end of a set of terms and conditions, or one of the things you should agree as part of a set of terms and conditions, is if there's a dispute, what court should deal with the dispute and what law shall apply. Mm-hmm. And if I'm writing terms and conditions in the UK, I would be saying, well, the law of England and Wales should apply. And if there's a dispute, then the courts of England should deal with the dispute. That makes sense. However, I've lost count of the amount of times that people have asked me to look at their terms and conditions, and I've seen there's been an American jurisdiction clause, particularly when it comes to the IT sector actually, but they quite often will say that any disputes will be dealt with under California law, and the California courts will deal with any jurisdiction. So you might have that arrangement between you and your English customer, but if you've all agreed to the California courts to deal with any disputes, that's where those proceedings have to take place. So that's ridiculous really, because if they haven't paid you and you've got to sue them to be paid for your goods or services you provided, technically you've got to go to the American courts to pursue that action. It's meaningless, but those are the kind of problems that do happen because people don't check these things before they start using them on a day-to-day basis. Yeah, it works both ways. So what I've talked about today is about terms and conditions with your customers. In other words, when you sell your goods and your services, you're setting out clearly the terms upon which you are selling those goods and services. But you're quite right, when you are buying services in, so in a purchase order situation, you should be doing the same thing. You should be trying to say, these are the terms upon which we wish to buy these goods. Now, if you've got really savvy suppliers, of course, they may already have their own terms as well, that they want to supply you on, and then you have this issue about which terms are going to apply. Do the supplier's terms apply, or do your terms as the customer's terms apply? And there's a whole issue in law called the battle of the forms about which is the terms that will take priority over the others, which is often quite complicated to get to the bottom of. There's always lots of disputes about that. The answer usually is which is the last set to be sent before the contract is made. But also, lots of suppliers do not necessarily have their own terms at all, and so therefore, if they haven't got them, they will buy on your purchase order terms. Then your purchase order could have a set of terms and conditions on the back of it that they may just accept. So sometimes it's worthwhile having those, and see you can mitigate your risk as a business by doing that. I've also had situations where clients have wanted to set up a preferred supplier list. And as a condition of suppliers being on that list, they have to sign up to the customer's purchase order terms, which then of course are favourable to the customer in that situation rather than the supplier themselves. But that is a great way of sort of making sure that you've mitigated your risk from your supply chain too. Well, as getting paid is probably the most important thing. Make sure your terms and conditions have clearly got your payment terms in there, and that there's an implication for your customer if they don't pay you on time, whether that's suspension of future delivery, suspension of service, or paying interest on any outstanding amounts. Secondly, I think the most important thing is, particularly if you're a company that's selling goods, is make sure that ownership of those goods does not pass until such time as you've been paid for them. Get that wrong, the company could go into insolvency and the customer could go into insolvency, and you will lose those goods. It'll be very, very difficult to get them back because you've just been unsecured creditor in the insolvency. It's really important to get that right. Thirdly, inevitably from time to time you're going to get some disputes with your customers. You want to make sure that the disputes are handled on your terms, so you know what the dispute resolution procedure is going to be, and you know that if there's going to be a court case that follows from it, that it's in a court that that's close to where you are, because you don't want all the additional costs associated with having to go to court in other territories and other jurisdictions. I think it's really important with your terms to make sure that they are clear and concise. Really, they need to be easy to read. If you're dealing with consumers, you're really supposed to be writing terms and conditions in plain English nowadays to make sure that it's easy for a consumer to read. There are laws around that. The Consumer Rights Act in particular does talk about writing terms in plain English so that people understand what it is they're signing to. And the more clearer they are, the more likely that a court is going to side with you in the event that there is a dispute. I suppose the last point really is you shouldn't be copying somebody else's terms and conditions for the reasons I've already outlined. They belong to somebody else. Somebody else owns the copyright in them. If you're going to do that, you're going to infringe their copyright. You shouldn't be running your business on the basis of how somebody else wants to run their business. You should run the business the way you want to run it. You don't want to find yourself in the situation that our friends at Seabourn Freight found themselves in, being humiliated as a result of them having copied somebody else's terms.